redacted. Redacted DB a Peyton Charles, plaintiff counter defendant. Fifth redacted, defendant counter plaintiff. In the county court at Law No. Dallas County, Texas. Opposition to motion for new trial and recusal. To the Honorable Presiding Administrative Judge and the Judge of said court, comes now redacted, defendant and counter plaintiff in the above styled and numbered cause, appearing pro se, and files this response in opposition to redacted Peyton motion for new trial and motion to recuse pursuant to Texas Rule of Civil Procedure 18A, respectfully showing the court as follows. First, introduction and summary. Finality of judgment. Following comprehensive bench trial on July 2nd, 2026, this court entered final judgment on July 7th, 2026, cleanly disposing of all claims and parties on their merits. Plaintiff's meritless posturing. Plaintiff now seeks to set aside the final verdict and recuse Judge Jones based entirely on subjective dissatisfaction with standard courtroom pacing and evidentiary adjustments. Bad faith tactics. Plaintiff's motions represent bad faith extension of an extrajudicial campaign to dox public school educators, manipulate digital platforms, and ignore the finality of judicial decisions. Plaintiff identifies no facts showing personal bias, prejudice, or any other circumstance that would cause a reasonable person to question the court's impartiality. Instead, plaintiff's complaints arise from the court's management of the preceding evidentiary determinations of and rulings made during trial. Disagreement with those judicial actions does not transform them into valid basis for recusal or new trial. EL, argument and authorities. A, the strict legal standard for recusal is not met. The impartiality presumption under Texas law, a trial judge is strongly presumed to be impartial, and the moving party bears heavy burden to overcome this presumption. In Re MCM 642 SW 607, rulings are not biased. The Supreme Court of Texas has long held that judges' ordinary courtroom administration, time restrictions, or expressions of impatience do not constitute valid grounds for recusal. Likey v. United States, 510 U.S. 540. Dow Chemical Company v. Francis, 46 SW 200 admonishments. Plaintively ignored direct admonishments from the bench to cease public commentary regarding ongoing litigation. From plaintiff and her out-of-state associates contentive court records online to target defendant. Attacking the judiciary, having failed to secure her desired outcome at trial, plaintiff is weaponizing the recusal process to publicly disparage the competence of the judiciary simply because the court properly understood the true nature and context of this dispute. B. Motion for new trial cannot be used to relitigate sound judicial discretion motion. For new trial is not mechanism for an unhappy litigant to force total retrial over routine discretionary rulings regarding unauthenticated medical notes or hearsay police reports. Plaintiff has not identified material error that prevented her from presenting her case or that probably caused an improper judgment. The court heard plaintiff's testimony, allowed her to present witnesses and exhibits, and extended the trial beyond its original scheduled time. Plaintiff's dissatisfaction with how the court allocated time, evaluated evidence, or ruled on objections is not basis to retry the entire case. Monopolizing courtroom time, plaintiff complains regarding trial restrictions, yet the record reflects that the trial extended significantly beyond its scheduled time frame solely because plaintiff monopolized the timeline with redundant cross-examinations. Streamlined adjudication, defendant presented focus, streamlined defense relying on direct, credible testimony, which provided the court with an entirely sufficient basis to render fair and balanced final judgment. C. Continued extrajudicial conduct, harassment, and false platform accusations. Plaintiff's continued extrajudicial conduct is included not to relitigate collateral disputes, but because it provides context for the present motions. That conduct demonstrates that plaintiff's recusal request arises from dissatisfaction with the judgment and an ongoing effort to publicly attack defendant, third parties, and the court, rather than from any objectively reasonable basis to question the court's fairness or impartiality. The conspiracy theory. Since the trial concluded, plaintiff has developed an obsessive fixation claiming that defendant is secretly behind independent online documentary and reaction channels, such as the outlet after the receipts. Targeting third parties. Based entirely on this false narrative, plaintiff has aggressively targeted these independent content creators, threatening them and filing fraudulent copyright and privacy complaints to systematically strike down third-party platforms for simply discussing the public facts of her trial loss. Of legal privacy, plaintiff's pattern of harassment extended to making unauthorized, intrusive inbound calls to defendants treating medical providers in bad faith attempt to probe confidential patient health records. Educational disruption. This fixated behavior highlights that plaintiff's filings are an extension of vindictive harassment campaign designed to leave defendant no peace as new public school year commences. IL, prayer wherefore. Premises considered, defendant redacted respectfully requests that the regional presiding judge and this court deny plaintiff's motion to recuse and motion for new trial in all things. Find that plaintiff has not established grounds for recusal or new trial. Uphold the final judgment entered on July 7th, 2026, and grant defendant all further relief to which she may be justly entitled. Respectfully submitted,